Before you begin, I invite you to subscribe to our YouTube channel.
Hello guys, welcome to my channel. And if this is your first time of visiting this channel, please don't forget to subscribe to my channel and don't forget to turn on the notification bell to get notified whenever we upload new videos. Thank you. Now let's go to the news of today, which says Nigerian government lacks power to detain Sowore Dasuki against court orders by Femi Falana. This is coming as a response to the Attorney General of the Federation, Mr. Abubakar Malami San, after claiming that Sowore and Dasuki were released on a compassionate ground. Now, let's go to the details of the news of today. Since the release of Omoyele Sowore and Sambo Dasuki from illegal custody on 24th of December 2019, the Attorney General of the Federation and Minister of Justice, Mr. Abubakar Malami San, has put himself under undue pressure. In the process, he has embarrassed the executive and exposed the judiciary to ridicule. After announcing that he had directed the State Security Service to release Sowore and Dasuki from custody in compliance with the court orders that had granted them bail, the Justice Minister turned around to say that the release was an act of compassion and mercy on the part of the executive. I was compelled to challenge the claim of the Justice Minister, as he lacks the power to release any person standing trial on compassionate grounds by virtue of Section 175 of the Constitution. After he had rightly abandoned that dangerous legal route, Mr. Malami has since asserted that the Nigerian government was right to have detained Sowore and Dasuki in defiance of the court orders which had admitted them to bail. In support of the outlandish contention, the Justice Minister said that the government was not bound to obey the court orders until the final determination of the appeals filed against the court orders. In an interview held on NTA last Thursday, the Justice Minister said there were appeals for stay of execution all through. So until those matters reach the Supreme Court and the Apex Court takes the final decision relating there, you are still operating within the ambit and context of rule of law. So in respect of those orders, we're not comfortable with as a government. We go back to the court and have them challenged until the matter that's your right of challenge is determined up to the Supreme Court level. The idea of you being charged with disobedience of court orders does not arise. With respect to the minister's statement, it's factually and legally erroneous in every material particular. If the Justice Minister had had time to review Sowore's case file, which he had withdrawn from the State Security Service, it would have confirmed that no appeal was filed against the two decisions of the Federal High Court, which admitted him and his co-defendant, Mr. Olawale Bakare, to bail. Instead of challenging the orders granting bail to Sowore and Bakare at the Court of Appeal, the State Security Service had actually attempted to constitute itself into an appellate court over the Federal High Court by insisting on approving the sureties that had been verified by the trial court. As Defense Counsel, we rejected the illegal request to produce the sureties before the Director General of the State Security Service until Justice Ijoma Ojukwu gave him a 24-hour ultimatum to release the duo from illegal detention. It is on record that Dasuki was granted bail at different times by 6 judges of the Federal High Court and the Federal Capital Territory High Court. It is pertinent to note that the Nigerian government did not file an appeal against any of these 6 court orders. In fact, the first bail application of Dasuki was not opposed by Mohammed Diri SQ, who was the then Director of Public Prosecutions from the Chambers of the Attorney General of the Federation. Hence, Dasuki was admitted to bail in self-recognizance on August 30, 2015. However, not opposed the bail application, government could not have filed any appeal against the order of the court. Apparently frustrated with the contemptuous conduct of the Nigerian government, Dasuki approached the ECOWAS court for redress. In a landmark judgment delivered on October 4, 2018, the ECOWAS court indicted Nigeria and awarded 15 million naira damages in favor of Dasuki for his detention in defiance of the orders of Nigerian courts. According to the judges of the court, it appears that the sole aim of the rearrest is to circumvent the grant of bail and by keeping the applicant in custody through executive fiat unsupported by any law or order of court. On the allegation that Dasuki was facing a serious charge of the criminal diversion of sum of $2.1 billion for purchase of arms, the ECOWAS court said that for the avoidance of doubt, any persons who have violated the criminal laws of a state, especially the ones impeding the development of the state and destruction of its commonwealth, are liable to be tried and if found guilty should face the consequences of their actions. However, in doing so, state must respect all international obligations with regard to the due process and the respect for fundamental rights of the suspects. Failure to do so will impute responsibility to the state regarding such violations of rights while leaving intact their right to prosecute and punish offenses against their criminal laws. It is submitted that the Nigerian government could not have filed an appeal against the judgment because the ECOWAS court is a judicial tribunal of first and last resort without any right of appeal. However, after the judgment of ECOWAS court, Justice Ijeoma Ojukwu of the Federal High Court had caused to admit Dasuki to another bail, but asked each of his sureties to deposit 100 million naira with the court. The government did not file an appeal against the ruling, but Dasuki did, as he was completely dissatisfied with the suffocating conditions attached to his bail. The appeal was decided in Dasuki's favor, as the bail conditions were varied in liberal terms by the Court of Appeal. The Nigerian government never approached the Supreme Court to challenge any aspect of the judgment of the appeal court. In the same vein, the government did not file any appeal against any of the orders of the high courts, which had admitted Sowore and Dasuki to bail. Consequently, no motion was ever filed for stay of execution of any of the court orders. Since no notice of appeal or motion for stay of execution was ever filed by the government against the orders of bail for Sowore and Dasuki, the Justice Minister ought to tender a public apology for misleading the Nigerian people. However, if the Justice Minister can produce any notice of appeal or motion for stay of execution in respect of the two cases, I will publicly apologize to him for misleading the Nigerian people. From the foregoing, it is undoubtedly clear that the two orders of the Federal High Court admitting Sowore to bail were treated with contempt, while the 8 orders of the Federal High Court, Federal Capital Territory High Court, ECOWAS Court, and the Court of Appeal, which admitted Dasuki to bail, were ignored by the Nigerian government based on erroneous legal advice. A couple of weeks ago, I had reminded the Justice Minister of the fact that as a military dictator, Major General Muhammad Buhari had complied with court orders by releasing 13 political detainees from the legal custody of the notorious National Security Organization, now State Security Service, based on the legal advice of his Attorney General, the late Chief Chike Ofodile San. Even under the dreaded Sani Abacha junta, the law was not totally silent. Hence, when I was detained in 1996 under the State Security Detention of Persons, Decree No. 2 of 1984, at the Mawadashi prison in Jigawa State, the Federal High Court granted an order permitting my wife to visit me, and upon the service of the order of the government, the then Attorney General and Minister of Justice, the late Chief Michael Agbamuche San, advised the prison authority to comply with the court orders. At about the same time, Mr. Agbamuche equally advised the Abacha junta to comply with the orders of the Court of Appeal, permitting the wife and personal physicians of the late Chief Gani Faweimi San to visit him in the Bauchi prison. It is on record that the Abacha junta complied with both court orders in line with the advice of the Justice Minister. Therefore, if the court orders issued in favor of the opponents of military dictators were respected under the defunct military regime, It is unacceptable for a democratically elected government, which operates under the rule of law, to ignore the orders of municipal and regional courts for the release of political detainees and criminal suspects from illegal custody. Inasmuch as the eventual release of Sowore and Dasuki is appreciated, it ought to be pointed out that this is a mere tip of the iceberg. If the Nigerian government has genuinely decided to embrace the rule of law, it has to comply with all valid and subsisting court orders and respect the human rights of the Nigerian people. As a matter of urgency, the Justice Minister should direct the authorities of Nigerian Police Force, Nigerian Correctional Service, State Security Service, Armed Forces, anti-graft agencies, and other law enforcement agencies to either release or prosecute the thousands of criminal suspects, including terror suspects, that have been incarcerated for months without trial. The detaining authorities should also be prohibited for parading suspects and subjecting them to physical and mental torture, in contravention of the provision of Section 2 of the Anti-Torture Act 2017. Furthermore, the Council of the National Human Rights Commission, which was dissolved in 2015, should be reconstituted by the President on the recommendation of the Justice Minister. In June last year, President Buhari directed the Office of the Attorney General, the Inspector General of Police, and the National Human Rights Commissions to carry out the reforms of the Special Anti-Robbery Squad of the police within 3 months. It is high time the directive was carried out. The George Will Judicial Commission of Inquiry, which investigated human rights abuses in the armed forces, submitted its report on February 2018. The government should issue a white paper on the report forthwith. The Garba Judicial Commission of Inquiry, which investigated the military invasion of Zaria in December 2015, recommended the prosecution of the military officers who massacred 347 Shiites and buried their bodies in a mass grave. The indicted suspects should be charged with culpable homicide at the Kaduna State High Court without any further delay. Owing to the refusal of the Nigerian government to act on these reports by prosecuting those who bear fully responsibility for such egregious human rights infringements, the Office of the Special Prosecutor of the International Criminal Court has concluded arrangement to open the preliminary investigation into allegations of crime against humanity concerning the extrajudicial killings of members of the Islamic movement in Nigeria and indigenous people of Biafra. It is hoped that the government will not allow Nigerians to be exposed to international opprobrium for our unwillingness and inability to prosecute an indicted murder suspect. So guys, that is the content of the news for today. But to start with, how would the AGF would have made such a statement that Sowore and Dasuki were released on a compassionate ground? You know, where there is law that governs everybody in the country. If the law says do this, then no other person has the power to reverse it. As long as a competent court has granted bail to anybody, no matter your crime may be, as long as it is coming from a competent court or from a judge, as long as it is under the rule of law, then if you are not satisfied with the rulings, the next thing you do is to approach another court, probably an appeal court. You know, so saying that you are giving Sowore, you are releasing Sowore based on compassionate ground, are you saying the rulings of the judge is not really necessary? And if it's not really necessary, why did we have the judge in the first place? Why do we have the court in the first place? Why did you charge the person to court in the first place if you know you cannot obey the court rulings? So all these things, it's really annoying. But when you are hearing this as a Nigerian and you are hearing this from an AGF of a country like Nigeria, anybody hearing this kind of things in all over the world, they will begin to laugh and say, how would you release somebody who is already granted bail and you say you are releasing that person on a compassionate ground, on a mercy ground? As what? Is it as Christmas gift or what? Or as New Year gift? It's actually so unfortunate the kind of people we have representing us, people who are, I don't know, is it lack of proper education that has made us, have this kind of people in power, or, a man no man policies that we play in Nigeria. This kind of people is like they don't even understand what the law says. The law they think they govern over. If not, how would you say you are releasing a detainee on a compassionate ground? That statement alone is an insult. Is an insult, is an embarrassment to the Nigerian population. Telling us that you are releasing a detainee on a compassionate ground, as in on what level? But probably many of them does not even know the gravity of statement they made at times, saying you will release somebody on compassionate ground, somebody who is already granted bail. So you don't have right to release anybody on compassionate ground if the law of the land has not set the person free or grant the person bail. It's obvious these people don't know what they're doing. But you see, guys, I don't want to be the judge on this matter. I would like to hear your views in the comment section, and please don't forget to subscribe to our channel if you haven't, and don't forget to share this message, and don't forget to give it a thumbs up. Thank you. Till I come your way next time. Have a wonderful week ahead. Bye.